And welcome back to the Financially Simple Experience. You know, we've been talking about this world of legalities, legal law. Yeah, it could be a little bit cumbersome for us as business owners. And we've dealt with many different subjects in the past. But today, joining me in the studio is Miss Julie Eisenhower. How are you?
I'm very well. How are you?
I am blessed. Too blessed to be depressed, actually, if you want to know the truth. So, friends, Julie, she joins us with her law firm, Triamicus.
Yes.
Did I say that correct?
That's correct.
What is Triamicus?
So amicus means friend of the court. And the tri represents for our firm our vision, our values, and our mission.
Okay. And your specialty is that of estate planning,
Yes,
am I correct?
it is. I focus on estate planning, probate, and I also will settle estates as a court-appointed personal representative.
So let me start off with probably the easiest question of the day, and that is how do you look at estate planning differently for a business owner as opposed to a non-business owner?
Well, it's very important, of course, to capture what type of business entity that the business owner has. That is going to dictate then the specific language and provisions that will be inside of the trust instrument or inside of a will. And it will also dictate how we're going to set up a plan. Very important, because let's say that you have a sole proprietor. Well, they are the business. Right. They are the brand. It may not be possible for a sole proprietorship to be then passed on down in a legacy. So how do you capture the intention of that business owner and also provide the tools and guidance in that roadmap, which we call the trust instrument or the will instrument?
So then if somebody, you mentioned sole proprietor, I'm working a particular case right now that it was a C Corp.
Mm-hmm.
5-6 years ago.
Right.
They converted to an S Corp. Each one of those type of entity structures, maybe even an LLC tax as a partnership,
right.
Each one of those are going to have different
That's
estate planning provisions that you'll have to address.
Yes.
Am I right?
And very important too, because you want to make sure that the business entities such as an LLC, an S Corp, a C Corp, that they have the proper documentation for their business entity. That those documentations, such as an operating agreement within an LLC, is speaking to, well, what happens to when a member dies? What happens is if there's no language within those documents, is it going to default to state law to interpret that? And then you also then want the estate plan to reflect those documents in those particular provisions regarding the death of a member or stockholder, and what the communication will be between the executor or the trustee in working with those surviving members or stockholders of that business. Very important to capture that.
So from a real world case, let me see if I can give an example, and let's kind of talk through this case a little bit. I know you and I like to get into all the details, and so we'll have just a little bit of information, but I've worked with in the past a LLC tax as a partnership.
Yes.
It was a husband who owned 99%, wife owned 1%. Mm-hmm. We see that quite often.
Right.
And husband was literally hit by a truck.
Oh,
gone.
Wow.
And inside the operating agreement, it did not have, or they didn't have even outside the operating agreement, there was no buy-sell agreement. Thank goodness they had a little bit of life insurance in place that could help the wife sustain, but they were left with this business that was not addressed anywhere within the last will and testament. There was no trust involved. Whenever you see a circumstance where you have maybe a disproportionate ownership interest, like let's say a partnership, whether it's an LLC or GP, general partnership, sorry.
Right.
How do you what mechanisms do you look at as part of the estate plan to help solidify or protect the business owner and the business and the employees and the customers from something like that?
Well, and that touches upon a very important aspect, that you do not want that business wrapped up in probate.
Right.
That's time consuming, that's expensive. The business itself is losing precious time of operating. And so we want to make sure that we are, when we're as a practitioner in talking with that business owner, to make sure, one, we're capturing intention of what they want that business to be like, look like, pass on upon their passing, and to capture that within the estate planning documents themselves.
You know, business owners often have most, if not all, considerable amount at least, of their net worth wrapped up in their business.
Yes.
We're right now working through 7 transitions where we have clients who are in the process of selling because of pending tax legislation, because of timing, various reasons, right? Capital, various other reasons. Whenever you're looking at this highly illiquid asset, and we're now looking at last will and testaments, trust, things of that nature, how can we protect the family in the event of an untimely death, untimely disability, maybe a divorce, maybe a business separation? How do you protect that asset so that the owners of the business can one day perhaps receive the benefit of this asset?
Right. And you would do that you can do that with a trust instrument that captures what needs to happen with that asset. You can also, estate planning is not just trust and wills. Estate planning is also, as you had touched upon earlier, it includes life insurance. It includes financials and making sure that the beneficiary designations are correct for those particular policies so that the survivor has quick access to needed income or unearned income, if we're speaking to those type of financials, and also that the liquid asset of the business itself is protected through the use of a trust instrument, for example. I don't like to be heavy on trust, but it is necessary when I'm reviewing the circumstances regarding especially a business owner. If a trust is appropriate, would it be better to have a testamentary trust created within a will document? Or would it be more prudent to create a trust instrument that will carry on upon the passing of that owner?
And testamentary trust created within a will document, that's a pretty common occurrence that I see often.
Yes.
Okay. So let's change gears here a little bit. This has been an unusual year for our practice. We've had more business owners receive inheritances of businesses. So let me kind of lay the foundation, and I want to get your insight on how you would address this. So obviously, we have business owners of every age. Let's say most of our business owners are 40 to 50, and then 40, 50 years of age, and now their parents owned a business. And in this particular circumstance, I'm thinking about, the business owner is already, burning the candle at both ends. They're working 80, 90 hours a week, and daddy passed away unexpectedly because of some health issues and left another business as an inheritance to this business owner. I've also had clients who've received inheritances in maybe monetary, real estate, various things this year. And we also had clients pass away that have left inheritances. Right. Whenever you're dealing with a business owner like myself, who have parents that perhaps could decease at a point and leave me a business that I have to deal with, how does that impact the actual documents that I've set up in place as of yet?
Oh, it will most definitely impact the documents that you have in place, your own plan. One, you have to see what your circumstances are personally at the time that you are going to be receiving that inheritance. Is it something, we'll take it away from also the business part, but just an inheritance in general, is it something that needs to be commingled with other accounts? Are you going through a divorce, for example? Are you wanting this to remain a separate property, or is it once it becomes commingled, is it going to become marital property? Which the designation doesn't come in unless we're talking about a divorce. And when we're talking about a business in particular for the inheritance, I would again say that there needs to be a review of any and all existing documents relating to that business that you're going to inherit, because you want to make sure you're following that roadmap. Those documents will trump what has been set up for the deceased estate plan. So you want to make sure that those documents, that the plans are following what that document says, if the document exists. So I know that's a general answer, but...
Well, but you bring up a very interesting point, something that I dealt with firsthand this year. So here's what happened. About 7 years ago, we had a business owner say, well, they needed some help. And they received a sizable inheritance, almost seven-figure inheritance in cash. And their estate planning attorney that we were working with at the time, wrapping up their estate plan, we came notice, and we brought up the point, said, hey, look, this money they're getting into this husband, why don't we set this in his name only account? We don't know exactly what the marriage, they have a strong marriage at this point,
right,
et cetera, et cetera. Now, fast forward years later, that money now has almost doubled in value. It was in husband's name, and a divorce transpired.
Right.
And that's, I think, what you're talking
That's
about when it goes
exactly what
co-mingling.
I'm talking about. Yes.
Can you dive a little bit deeper on what does it mean, co-mingling?
Co-mingling.
Just try and talk through me on the metrics of
Yes. So co-mingling is where you're bringing separate assets, separate monies into what we call the marital accounts.
Okay.
You are also then using that money for marital reasons. It could be putting that money into the marital home for an update in the marital home. It could be using that money for paying off loans or paying on loans that would be considered marital property. So anytime you're taking a separate asset, separate income, and putting it into the marital home, supporting that marital home, and when I say home, I mean the marriage, then you are commingling those funds. And then the court then, if a divorce happens to subsequently result, the court will then evaluate whether or not that fund is commingled and should be considered marital.
Have you ever dealt with a circumstance that talks that people have inherited maybe company stock in a closely held business? Can you commingle that company stock as well in that circumstance, or is there a way to prevent the inheritance of that company stock from being commingled?
Again, I would look at how that is set up first and foremost.
Where?
From the stock itself,
Okay.
how that was set up, and how the rules are, well, I say rules, or the plan that's in place of how the recipient, the beneficiary, is supposed to receive that. There's got to be a review of those documents, and there needs to be an exchange of communication with a financial planner to see what would be the best way of handling that type of an inheritance. That's where I would go to, and it would be a case-by-case basis, really, to see what would be the most appropriate.
So if we go back to our typical client, the typical listener, they're about our age.
Yes.
And they're dealing with kids who are leaving the house, and they're dealing with parents who are aging. And so
Yes.
they're dealing with both spectrums. I was I made a comment to a client recently with a child who now turned the age of 19, and they were past that 18 years of age. I said, you realize if they were to get injured, that you would need a power of attorney in
Yes.
place in order to help them at the
That's
hospital,
right.
various things. And they looked at me sideways, and they said, we just got finally a power of attorney on our parents. What's the importance of somebody having a power of attorney on maybe what they consider still a child at the right point? When does that impact? And what's the importance of having a power of attorney at the right time on maybe an aging parent? Can you kind of talk to that point?
Power of attorney is a very critical document. You are required to have a higher mental capacity to execute a power of attorney than you are for a will. So it's a very important document. When we're speaking about a parent having a power of attorney over a child who's recently become of age, 18 in our state, it's very important because the parent at that time when the child becomes 18, they no longer can speak for that child with financial institutions, such as if they're getting financial aid. And speaking about taxes, if there's taxes that need to be filed. And the same would be for an aging parent to speak on their behalf, to do any kind of banking for that parent, any kind of contracts that they need to enter into on behalf of that parent. And it allows the agent, that attorney in fact, to be able to step in their shoes and speak on their behalf. Now, there are different types of power of attorney documents that exist, and that would need to be reviewed as well with the client.
So I'm aware of a durable or general, depending on what terminology what attorney uses. Which one do you use, durable or general?
General, durable,
General,
power
okay.
of attorney, yes.
And then I'm also aware of a healthcare power
That's
of
right.
attorney. Where do you? I typically see healthcare involved, typically more with the 18-year-old, a little bit older. Do you see the financial power of attorney getting executed at that age as well, typically?
Not typically, but I would urge parents to do that, most definitely. And then there's the type, if you're going to talk about a springing power of attorney or one that is effective immediately upon execution of that document. Springing, of course, would be if a physician declared that declarant to be disabled. Then the power of attorney authority would kick in at that time. And it just depends on circumstances of when that would be appropriate.
So my wife and I, we have power of attorneys in place, and we have a immediate, I guess the term that maybe some would use, immediate power of attorney where she can sign as if it's me for financial matters, and I can sign if it's her. And we've used that many times. I'm traveling on business, and she needs to sign something for the business or the document. She can sign it, sign my name POA in that particular circumstance. But then if she's unable and I'm not able, then at that point, I think the springing mechanism would be my brother, for example, would spring into power to fulfill that position. Do I have that terminology or definition right?
In that scenario, it would be your successor, who is named as your successor within that document. Right. So if your wife is unable to fulfill that role or is incapacitated, then your successor then can step in.
Okay, perfect. Yes. So, one of the things that I love is I love to learn. You probably can see.
I do too, yes.
I love to read. We talked about this. I'm a nerd. I read books nonstop. I read a book a week. I have since I was like 16 years of age. Obviously we have books in here. You've seen my office. You've seen that we got books everywhere in this office, friends. If you want to know a good book to read, just ask. We love to read books. So you brought 2 books with you today, and I want to know why these books have impacted you.
Well, these are books that I'm about to dive into. One is called What Would the Rockefellers Do? It's a book that was recommended to me by another financial planner, and it's basically speaking to how to create a legacy, looking at models of family wealth in our country in particular, and taking some tips from that. So it is a book I want to delve into so then I can have some more ideas for estate planning. And then the other book, The E-Myth for Attorneys. Yep. This is a very common book, The E-Myth itself. But this in particular speaking to attorneys and how you don't want to be a technician in your practice. You want to be the actual owner and what those different hats look like and what to do as far as guidance on making your law practice excel.
It's exciting. Yeah, I often quote Michael Gerber's E-Myth. He's written several different disciplines for attorneys, for CPAs, financial advisors, dentists, chiropractors. There's several different versions of it. It all boils down to that one thing. There's 3 different people involved in a business. Right. We could be either the practitioner, which, we're not pretty good practitioners within our fields, right? Yes. Or we could be the manager. I am not a good manager, Julie. I got to tell you, I to try to make me manage people, I just seem to stick a fork in my eye, move to Idaho and sell llamas. It just is not me. But the business owner, I understand it. That's that's my passion in life. What's one nugget that you would leave to business owners or say, hey, if I could give you something to consider, this would be it?
Become a lifelong learner. Okay. Read. Become a voracious reader. We have access today in our world to primary and secondary sources and different types of mediums, reading, podcasts, maybe even YouTube videos, seminars. And my nugget would be to read, to learn, to constantly perfect your craft that you have as a business owner that you choose to do day in and day out, and on any other topic that you're wanting to try to master. That would be my number one tip.
Tony Robbins one time said, no one can take your education away.
Right.
And it always helps us in application. Right. So where could folks, if maybe somebody's in Tennessee, I think that's where you are licensed to practice. If somebody's in Tennessee and they say, hey, Julie, I really like your approach, I want to reach out to you, how could they get a hold of you?
Yes, so we have a really great website, triamicuslaw.com. Our phone number is area code 865-217-1154. We're located in West Knoxville, and we are a general law practice, and we are comprised of 4 attorneys at this time, and we can provide a variety of different legal services for prospective clients.
Thank you so much for joining me today.
Thank you. This was fantastic.
Sweet. I'm glad you were here. I'm glad you added value. So, friends, reach out to Julie if you're in East Tennessee, if you're in Knoxville especially, or maybe you're in the state of Tennessee. They're licensed to practice law all across the state. Look, if you have a question, maybe you're not in Tennessee, reach out to Julie and she can connect you with maybe a colleague of hers around the country or another individual in the law field in maybe your appropriate state. I realize that the legal world is complicated. I get it. It is very frustrating sometimes for those of us who aren't practitioners of law. It can be complicated. It can be hard sometimes. It doesn't have to be. Let's continue to make our lives at least financially simple. Hey, y'all, go out and make it a great day.